Welcome to the second video in our series, Legal Tips for Updating Your Estate Plan. If you've already created an estate plan, congratulations. You've taken an important step in protecting your loved ones and securing your legacy. But here's the truth. Estate planning isn't a one-and-done process. Life changes, your goals evolve, and your plan needs to reflect that. In this video, we'll walk you through the essential steps for assessing your current estate plan to make sure it's still aligned with your wishes. Whether it's updating beneficiary designations, revisiting your will, or ensuring your power of attorney is still the right fit, we'll guide you through everything you need to know. By the end of this session, you'll feel confident that your estate plan truly protects your legacy and meets your family's needs, today and in the future. Let's get started. Evaluating the components of an estate plan: will, trust, power of attorney, healthcare directive, etc. When updating your estate plan, it is essential to carefully evaluate the various components that make up a comprehensive plan. These components typically include a will, a trust, a power of attorney, and a healthcare directive. Each of these documents serves a unique purpose and plays a crucial role in ensuring that your wishes are carried out effectively and efficiently. Let's delve into each of these components in detail. Will. A will is a legal document that outlines how you want your assets to be distributed after your death. It allows you to specify who will inherit your property, assets, and belongings. When evaluating your will, consider whether your beneficiaries are still relevant, if your assets have changed significantly, and if your executor is still the right person to carry out your wishes. 2. Trust. A trust is a legal arrangement that allows a third party, known as a trustee, to hold assets on behalf of beneficiaries. Trusts can help you avoid probate, maintain privacy, and provide for specific needs of your beneficiaries. When reviewing your trust, assess whether the terms are still in line with your wishes, if the trustee is still capable and reliable, and if there have been any changes in your assets that require updating the trust. 3. Power of attorney. A power of attorney is a legal document that designates someone to make financial decisions on your behalf if you become incapacitated. It is crucial to ensure that the person you choose as your power of attorney is trustworthy, competent, and willing to act on your behalf. Reviewing and updating your power of attorney ensures that your financial affairs will be managed according to your wishes in case you are unable to do so yourself. 4. Healthcare directive. A healthcare directive, also known as a living will or advance directive, specifies your wishes regarding medical treatment and end-of-life care if you are unable to communicate your decisions. Evaluating your healthcare directive involves considering whether your preferences for medical care have changed, if your designated healthcare agent is still appropriate, and if there are any new medical treatments or technologies you wish to address in the document. Evaluating the components of your estate plan is a critical step in ensuring that your wishes are accurately reflected and legally binding. Regularly reviewing and updating your will, trust, power of attorney, and healthcare directive can help you adapt to changes in your life circumstances, protect your assets, and provide clarity for your loved ones. Consulting with an estate planning attorney can also offer valuable guidance and ensure that your estate plan remains current and effective. Identifying outdated or inadequate provisions in your existing estate plan. Reviewing and updating your estate plan regularly is crucial to ensure that your wishes are accurately reflected and that your loved ones are provided for in the way you intend. Identifying outdated or inadequate provisions in your existing estate plan is an essential step in this process. Below are some key areas to consider when evaluating your estate plan for necessary updates. Changes in family circumstances. One of the most common reasons for outdated estate plans is changes in family circumstances. This could include marriage, divorce, birth or adoption of children, or the death of a family member. Review your estate plan to ensure that it reflects your current family situation and that your assets are distributed according to your wishes. 2. Changes in financial situation. Changes in your financial situation, such as acquiring new assets or investments, can impact how your estate should be distributed. Make sure your estate plan takes into account any new assets or changes in your financial situation to ensure that your beneficiaries are properly provided for. 3. Updates in tax laws. Tax laws are subject to change, and these changes can have a significant impact on your estate plan. Review your plan to ensure that it is in compliance with current tax laws and take advantage of any available tax-saving strategies. 4. Beneficiary designations. Make sure that the beneficiaries listed in your estate plan are still valid and reflect your current wishes. This includes updating beneficiary designations on retirement accounts, life insurance policies, and other accounts that pass outside of your will. 5. Executor and trustee designations. Review the individuals you have designated as your executor, trustee, or power of attorney to ensure that they are still willing and able to fulfill their roles. Consider whether any changes are necessary based on the current circumstances of your chosen representatives. 6. Healthcare directives. Ensure that your healthcare directives, such as a living will or healthcare power of attorney, reflect your current wishes regarding medical treatment and end-of-life decisions. By carefully reviewing these areas and identifying any outdated or inadequate provisions in your existing estate plan, you can ensure that your wishes are carried out as intended and provide peace of mind for you and your loved ones. It is recommended to consult with an estate planning attorney to assist you in updating your estate plan effectively. Considerations for beneficiaries and heirs. When updating your estate plan, it is crucial to carefully consider the implications for your beneficiaries and heirs. Your estate plan outlines how your assets will be distributed upon your passing, and thoughtful planning can help ensure that your wishes are carried out smoothly. Here are some key considerations to keep in mind when updating this aspect of your estate plan. Clarity and communication. Clearly communicate your wishes to your beneficiaries and heirs. Make sure they understand the reasoning behind your decisions and are aware of any specific instructions you have included in your estate plan. This can help prevent misunderstandings and conflicts among family members after you are gone. 2. Update beneficiary designations. Review and update the beneficiary designations on your accounts and insurance policies. Ensure that the individuals named as beneficiaries are still the ones you wish to inherit those assets. Failing to update these designations can result in unintended consequences and assets being distributed contrary to your wishes. 3. Consider special circumstances. Take into account any special circumstances that may affect your beneficiaries, such as disabilities, financial instability, or age. You may need to establish trusts or other arrangements to provide for their needs and protect their inheritance. 4. Equal versus fair distribution. Consider whether you want to distribute your assets equally among your beneficiaries, or if a different distribution would be more fair based on individual circumstances. You may need to make provisions for unequal distributions and clearly explain your reasoning in your estate plan. 5. Addressing potential challenges. Anticipate and address any potential challenges that may arise with your beneficiaries. This could include family dynamics, disputes over assets, or disagreements about your decisions. Consulting with a legal advisor can help you navigate these potential challenges and find solutions. 6. Review regularly. Regularly review your estate plan to ensure that it still reflects your current wishes and circumstances. Life changes, such as marriages, divorces, births, deaths, or changes in financial status, may necessitate updates to your plan to ensure that it remains effective. By considering these factors and working with a qualified legal professional, you can update your estate plan with confidence, knowing that you have taken the necessary steps to protect the interests of your beneficiaries and heirs. Remember that thorough planning and clear communication are key to a successful estate plan that provides for your loved ones according to your wishes. Reviewing asset distribution and beneficiaries designations. Estate planning is a critical process that involves making decisions regarding the distribution of your assets after your passing. One key aspect of this process is reviewing your asset distribution plan and ensuring that your beneficiaries' designations are up to date. Failing to regularly review and update these details can lead to unintended consequences and disputes among family members. In this section, we will discuss the importance of reviewing asset distribution and beneficiaries' designations as part of updating your estate plan. 1. Regular review. It is essential to periodically review your asset distribution plan to ensure that it still aligns with your wishes and current circumstances. Life events such as marriage, divorce, births, deaths, or significant changes in your financial situation may necessitate adjustments to your estate plan. By conducting regular reviews, you can make sure that your assets are distributed according to your current intentions. 2. Beneficiaries designations. Beneficiary designations dictate who will receive your assets upon your death. These designations are commonly used for assets such as retirement accounts, life insurance policies, and payable on death accounts. It is crucial to review and update these designations as needed to reflect changes in your relationships or family dynamics. For example, if a beneficiary has passed away, or if you have had a falling out with a family member, you may want to revise your beneficiary designations accordingly. 3. Avoiding conflict. Failure to update your asset distribution and beneficiaries designations can result in confusion and conflict among your loved ones. Outdated designations may lead to assets being distributed to unintended recipients or beneficiaries being left out entirely. By reviewing and updating these details proactively, you can help prevent disputes and ensure that your assets are distributed in accordance with your wishes. 4. Seeking professional guidance. Estate planning can be complex, and it is advisable to seek the guidance of a qualified estate planning attorney when reviewing your asset distribution and beneficiaries designations. An attorney can help you understand the legal implications of your decisions, identify any potential issues, and ensure that your estate plan is comprehensive and up to date. Reviewing your asset distribution plan and beneficiaries designations is a crucial step in updating your estate plan. By regularly reviewing and updating these details, you can ensure that your assets are distributed according to your wishes and avoid potential conflicts among your beneficiaries. Remember to seek professional guidance to ensure that your estate plan is well prepared and legally sound. Understanding tax implications and strategies for minimizing estate taxes. Understanding tax implications and strategies for minimizing estate taxes is a crucial aspect of updating your estate plan to ensure that your assets are protected and passed on efficiently to your intended beneficiaries. Estate taxes, also known as inheritance taxes or death taxes, are levied on the transfer of assets from a deceased person to their heirs. By having a clear understanding of estate tax laws and implementing effective strategies, you can potentially reduce the tax burden on your estate and preserve more of your wealth for future generations. 1. Understanding estate tax laws. Estate tax laws vary by country and state, so it is important to familiarize yourself with the specific regulations that apply to your situation. In the United States, for example, the federal government imposes estate taxes on estates exceeding a certain threshold, which changes periodically. State estate taxes may also apply in some jurisdictions, further complicating the tax planning process. 2. Exemption and threshold. One key concept to understand is the estate tax exemption and threshold. The exemption is the amount of assets that can be passed on tax-free, while the threshold is the value of the estate above which estate taxes are imposed. By keeping your estate below the threshold or utilizing exemptions effectively, you can minimize the tax liability on your estate. 3. Tax-reducing strategies. There are several strategies available to minimize estate taxes and maximize the amount of wealth transferred to your heirs. These strategies may include lifetime gifting. Making gifts of assets during your lifetime can reduce the size of your taxable estate. There are annual gift tax exclusions and lifetime gift tax exemptions that can be utilized strategically to transfer assets tax efficiently. Trusts. Setting up trusts, such as irrevocable life insurance trusts or charitable remainder trusts, can help reduce the size of your taxable estate and provide additional benefits such as asset protection and control over distribution. Marital deduction. Utilizing the marital deduction allows for the tax-free transfer of assets to a surviving spouse, effectively deferring estate taxes until the second spouse's death. Estate freeze techniques. Implementing techniques such as grantor retained annuity trusts, GRATs, or family limited partnerships, FLPs, can help freeze the value of your estate for tax purposes, allowing for tax-efficient wealth transfer to future generations. Charitable giving. Donating to charitable organizations can not only benefit worthy causes, but also reduce estate taxes through deductions and exemptions for charitable contributions. 4. Consultation with tax professionals. Given the complexity of estate tax laws and planning strategies, it is advisable to seek guidance from experienced tax professionals such as estate planning attorneys and financial advisors. These professionals can help you navigate the intricacies of estate tax planning, tailor strategies to your specific circumstances, and ensure compliance with relevant laws and regulations. By understanding tax implications and implementing effective strategies for minimizing estate taxes, you can protect your assets, preserve your wealth for future generations, and achieve your estate planning goals with greater peace of mind. As we've explored today, assessing and updating your estate plan is more than just a legal necessity. It's an act of care for the people and causes that matter most to you. By keeping your plan current, you ensure that your legacy reflects who you are now, and that your loved ones are protected, no matter what life brings. Remember, an outdated estate plan can lead to unintended consequences, confusion, or even disputes among those you care about most. But by taking the time to regularly review and make adjustments, you're giving the gift of clarity, security, and peace of mind, not just for yourself, but for everyone who depends on you. Don't wait for tomorrow to take action. Whether you're updating your will, revising your beneficiaries, or ensuring your healthcare directives are current, these steps will empower you to protect your legacy. So, take this opportunity to make sure your estate plan is ready to evolve with you, and to give your loved ones the certainty and protection they deserve. You have the power to shape your legacy. Make it one that truly honors your life and values.